Welcome back, everyone. I'm your host, Mitch Simpkins, and this is Wins for Widows, where you get practical guidance from the mouth of professionals who all of us together are united in helping you get your feet on the ground after experiencing the loss of a loved one. Together, we'll uncover the rooted question that you might be asking yourself, what now? And what should I do next? Today, I am excited to introduce and host Michael Giles. Mike is an estate planning and tax attorney from Bennett, Tuller, Johnson, and Deere, BTJD, here in Salt Lake City, Utah. Mike works in the firm's estate planning and taxation groups, focusing on federal and state taxation, estate and gift tax planning, probate and trust administration, and helping families implement real-world, customized plans that actually work when life changes quickly.
Anticipate probably is what we try and do.
Okay.
And then help on the back end when we can.
It's good. Yeah, it's incredible. I know a lot of people say, like, can I really control that? Can I really specify that after I'm gone? And for the most part, the answer is yes, right? It's only limited to your creativity and thinking of some various scenarios that may or may not come up.
Yeah, I mean, you can really prepare a plan that is customized to what you want to do, what you want to see happen with your wealth or with your family. And there's lots of options out there, but it can get overwhelming because if you Google it or if you go onto AI, you're going to get overwhelmed with everything. Make sure people understand the consequences of maybe what they want to do and hopefully guide them in the right way to make it an easy transition.
It's got to be a challenge to think of. I know you can't ever think of every single possibility, right? But it's got to be a challenge to think like, okay, what can happen? Is there kind of a standard boilerplate for most documents that you use that kind of has already caught it all? Tell us a little about that. Like, tell me a second about, like, how do you plan? How do you prep? What do you use to kind of build these documents?
Yeah, there's really no way to catch it all, but the documents that we use are, the result of a combined over 100 years of experience with our estate planning attorneys at our firm. And so when we can anticipate a lot of things that could happen, and we can anticipate a lot of things that should happen and will happen. And that's why some of those documents are so long, right? People will get our trust and it'll be 30 pages long or something like that.
Yeah. Yeah.
And I've had clients, roll their eyes. Oh, this is just boilerplate. What is that? Well, the boilerplate is there as guide to your trustee to make sure they can handle any kind of situation that happens in the future. Things like what happens if one of your beneficiaries becomes disabled? What happens if one of your beneficiaries passes away before you do and you don't get a chance to change the documents? What happens if there's a tax issue that comes up? What is the trustee supposed to do to sell assets or to gather assets? All of those powers and things, that's really what's in there. And so we try and anticipate a lot of things, but in the interview process, we try and pick up on maybe some custom or some more, unique things to somebody's life.
Things. Yeah.
That they have, and we can build that into the document that would be beneficial to them.
Yeah. No, that's great. No, cool. Good insight. Good insight. So speaking of special cases, one of the stories in the examples cases that you talked with me about was the case where a second death of a spouse happens super fast.
Right.
And they weren't able to really update the inherited IRA, and it forced everything to go into probate. So for widows and older couples who are listening, what are the key beneficiary mistakes that you see, and how can they avoid these costly surprises? I imagine the probate case was not inexpensive, or maybe any resulting issues that came from it.
Yeah. So that in that case, we had a couple that had a large amount of their assets were in retirement accounts, and they had both been professors and just built up their retirement accounts.
Yeah.
And they had 2 children, but they also had a lot of grandchildren. And they wanted to give something to everybody out of those retirement accounts. And so at the time we prepared the accounts or prepared the estate plan, we helped them prepare a custom beneficiary designation because there was some contingencies they wanted to build in, if not A, then B, and if not B, then C. And a typical beneficiary designation form doesn't really have, a lot of room to put that kind of stuff in there. So,
and when you told me that, Mike, I'd never even heard that you could do that. That was like brand new to learn that you could customize some of that as an actual beneficiary. You had to go to the company get them to approve it, right? The custodian had to approve that.
Right. We just had to send it into the right place
Yeah.
and then have them acknowledge that they received it. And so they had set that up, and obviously the first in every case where there's a married couple, we tell them that the primary beneficiary should be the spouse, because that gives the best chance to stretch out the tax consequences of those retirement accounts.
Mm,
Unless it's a Roth account, it's going to be a tax deferred account. And so that's going to, we want to stretch out that tax, the distributions as long as we can, so we don't have to recognize the tax all at one time. So the spouse is named as the first beneficiary, and then after that, then we have these custom beneficiary designations. Well, in this case, we just had a couple that he just happened to pass away. He got cancer and passed away pretty quickly. And then she passed away maybe 6 or 7 months later,
mm,
and didn't take. And so here's one of the, well, back to your question. Your question is, what are the big things that you need to look out for? First, it's making sure that you actually do a beneficiary designation. If you're going to
yeah.
if you're going to go to the lawyer and pay thousands of dollars to do your estate plan and have your
Yeah.
trust put together,
Yeah.
make sure you actually fund the trust, and you make sure you direct your assets
Yeah.
to that.
Yeah. One thing to have a trust, it's another thing to actually use a trust. And those are mutually exclusive. And sometimes
That's
people
exactly
do the
right.
first without doing the second, right?
That's exactly right.
Yeah.
So this couple obviously did that, and we got the beneficiary designations in place. But when the husband passed away, the wife didn't have an opportunity to go to the financial custodian and change the beneficiary, or even to put that account into her name. And so that's the first error we see, is that a spouse passes away, and then the surviving spouse just never goes and
Mm,
talks to the custodian. The
mm,
custodian doesn't even know that the
mm,
spouse passed away.
mm,
And so that IRA remains in the name of the deceased spouse. And in this
mm.
case, if that happens, then one, you're still basing all of required minimum distributions on the deceased spouse's age, or you could miss required minimum distributions from that account, which would be a problem. And it's just more complex, right? And so the first step is, if a spouse passes away, make sure you go talk to the custodian, let them know, because what should happen is that account should get rolled over into a retirement account for the surviving spouse, and it becomes as if it's their own account.
A spousal IRA, right? Versus a non-spousal.
Right. Right. And that's if the spouse is the beneficiary, right? There's different rules for when kids are beneficiaries, and we'll talk about that in a second. But in this case, she didn't do that. And then she passed away. And so the result of that is, when the kids they come in and they start managing the trust and start managing the estate, we did this custom beneficiary designation, and it says it first goes to the spouse, and then after the spouse, it would go to these
Kids or
kids or the
grandkids.
grandkids in
Yeah.
this special way.
Yeah.
But because she didn't go to the custodian, it never got rolled over into her account.
Mm,
But the custodian still treats it as if it was transferred to that surviving spouse. So
mm,
the custodian will look at it and say, all right, this account is a rollover IRA, a spousal IRA. You never made any, but they're going to say the surviving spouse never made any beneficiary designations. And so they have to go to the default rule on that beneficiary designation. And then the default rule usually is that it goes to the estate. And in this case, that was particularly bad, because within the custom beneficiary designation, we had 2 sons. One son was the good son and did everything that the parents wanted them to, and one son was, not so good. So second son's share was supposed to go into a trust for that son, and it was supposed to be protected for the benefit. And you were supposed to share with all the grandkids in different percentages. Well, if it goes to the estate, you don't necessarily get that custom division that would happen in the estate. In the estate, everything just got divided between the 2 sons, and so the grandkids could have been aced out of that.
Interesting. So who had to request the probate? Was that the
the person
sons?
representative, the sons, right?
The son said, "No, this ain't it. We've got to change it." And so they had to go through probate to then
Well,
have it reversed.
yeah, they went to the custodian and said, hey, we want to get access to our dad's retirement account. And the custodian said, well, the beneficiary is the estate. And so you've got to go open a probate to have an estate so that you can actually claim these funds. We're not going to give it directly to you. We're going to give it to the estate, and then the estate will roll it over.
Otherwise, the estate would have never had to been opened, right?
Correct. Yeah.
And
Otherwise, it would have
therefore, when
been,
the estate doesn't have to be opened, then that's when you didn't have to do probate.
yeah. If she would have,
Okay.
if the spouse would have gone, it would have got added to her account, and then her custom beneficiary form would have addressed it, and it would have all been fine. It
Interesting.
wouldn't have had to
And it
open the
would have
estate.
been fine. Oh, wow. That wasn't fun for them
No.
at all. So talk a second about like that distribution period, right? Because there's a 10-year distribution and there's a lifetime distribution. Used to be, there wasn't really a 10-year until the tax laws changed. So tell us about that, how it relates when you're talking a spousal versus a non-spousal recipient or beneficiary.
Sure. So as you said, it used to be, it used to be different than it is now. But today, if a spouse is the beneficiary, there's some other exceptions as well for like a disabled kids or whatever. But really, this rule applies to spouse. A spouse gets to treat the account as their own, and they get to roll it over, and so they get to use their own life expectancy
I see.
to take out the distributions.
That 10-year rule doesn't apply in that case if
Right.
it's a spousal.
Right. If it's anybody but the spouse, then you've got a 10-year rule that says the person has to take out all of the funds within 10 years
Mm-hmm.
of the date of death.
Hmm.
If you're a beneficiary. Now, if there's another rule, there's a 5-year rule for trusts. If the
Mm.
trust isn't drafted the right way, then if you leave your retirement account to a trust, then the trust has to take it out within 5 years. So you want to make sure that you understand those rules. And the 10-year rule, just a caveat there, it's different. It's a little bit different depending on when the person dies. If they die before they're taking required minimum distributions, then the beneficiary can wait the entirety of the 10 years and take it all out after, in year 10. If the person, the decedent, is already taking required minimum distributions, then the beneficiary has to take out a required minimum distribution every year for that 10 years.
Okay.
They don't have to take it out. They don't have to take it out in tenths. All they have to do is just calculate the required minimum distribution based on their life expectancy.
Okay.
And then they have to take it out.
Interesting. And by that 10th year, though, it has to all come out.
It all has to come out. And so
Right.
what's going on is the IRS just wants to tax it sooner. And this was a compromise to get some additional tax cuts passed, right? So they said, oh, well, if we accelerate the taxation of a bunch of IRAs then we can
help that.
we can pay for that
Interesting.
tax cut other places.
Interesting. Okay. Interesting. So if there is that 10-year rule, if there's RMDs, and it just has to be a certain amount, not the full amount.
Right.
But so it doesn't have to be 1/10 of the entire every single year. They can wait and then take their RMDs, and if there's whatever's left over in that 10th year, so say somebody's going to retire and they're making a lot of income, boom, boom, boom across, and then they get to that 9th year and they retire, they probably would want to wait, right, and take that big old section of it out that 10th year. So it does leave a little bit of flexibility there for them.
It does, and the reason there's a difference,
but
yeah, the reason there's a difference is because it's the minimum distribution is based on your life expectancy, not the 10 years.
Okay.
And so
Okay.
if I received it as my age, my life expectancy is 30 years.
Okay.
And so I could take it, mine's gonna be 1/30th in year 1, 1/29th in year 2, and so on. So you're gonna have some left in year 10.
Mm-hmm. Mm-hmm.
But that's just the minimum you have to take. You can take more sooner if it makes sense.
Right.
But
You
that's
just
just
you just have to do it. Yeah, interesting. Yeah, great information. So, Mike, do you recommend people using a trust as a beneficiary on a retirement account, or individuals, or does it depend?
It depends. When I talk to folks, I tell them, we talk about these rules, and if you trust your kids and you're just going to give your estate to your kids anyway, the administration is easier if you just name the kids as successor beneficiaries to your spouse. Then they're going to get their share. The downside to that is, again, it doesn't really provide for the contingency. Well, what happens if that kid predeceases you? Some plans will require that it goes to the other beneficiaries, so it just goes to the other siblings, even if that deceased beneficiary had descendants, had kids. It wouldn't drop down to their kids; it would just go to the other siblings. Some do the other way, and so it just depends on the plan. You have to figure out what the plan says. So that's the only downside of that, but it's very simple to get the 10-year rule. You're an individual, you're going to inherit this account. It's going to be an inherited IRA in your name. Easy to do. You don't have to submit a trust to the custodian and have them review it and make sure that it qualifies.
Yeah.
But if you have if you've got a disabled child, or if you've got a child that that you don't want to receive a large lump sum of money because you think they're
Okay.
just going to blow it or harm themselves,
Yeah.
then let's use the trust and we'll deal with, we provide language in there to make it so that the trust qualifies for the 10 years.
Okay. Okay.
But you just have to go through more of a process with the custodian to get that.
I've administered a few of those over my lifetime as a financial advisor, with a trust being the beneficiary. And it definitely wasn't as easy as working directly with an individual. You still have that trust entity, and it just created some additional steps that we had to go through and some additional things. What about if kids are named as beneficiaries that are not 18, 21? What happens then? Where does it go?
Right. Typically what happens is the custodian will set up what's called a uniform transfers to minor account. That's an inherited IRA account. Then they'll just find somebody who will be a custodian. Usually that minor child's, if they're a minor child of the parent that passed away, that they would find somebody, whoever's going to be their guardian,
The
would
guardian. Okay.
become
Would
the
become the trustee,
custodian, the custodian of that
the
account.
custodian of that account. Okay.
Those uniform transfer to minors accounts, they require distribution of the account to the beneficiary or to the minor when they turn 21. At least in Utah, it's
Okay.
21.
Okay.
Might be a different age and in different states. And so the kid would take over managing that account when they turn 21.
And before that, they can be used for their benefit, I guess, based on
Yes.
the custodian, whoever's managing that, right?
Yeah, the custodian can use it for their benefit. They're just subject to, they're essentially a trustee over those funds. And if they mismanage them, then they can be sued by when the beneficiary turns 21 and says, "Hey, what'd you do with all my money?" And they said, "Yeah, that
Yeah.
crypto didn't really work out for me." And the kid
It
can
used
police.
to until the last few weeks, boy. It's been volatile. You gotta have a heavy stomach the last few weeks with it.
Yeah,
Everyone was dancing in the streets before that.
that's right. Now they're crying.
Yeah, they are definitely. So Mike, we talked a little about divorce as well, and I know we're focused on widows, but loss also happens in the case of divorcees, and it's a rough time. And when a long marriage ends, and there's some large retirement accounts, a home, closely held business, what are the most important tax and the basis issues that they should understand before agreeing to split it out, right? What should you be thinking about if you are divorced or if you're considering divorce, to help make this quote unquote fair or equal?
Fair.
Yeah, fair. Is that all right? Can I use that word with divorce? Probably
Well,
not.
yeah. Well, everybody does, right? Both
Yeah, yeah, yeah.
sides say,
Yeah.
"Oh, that's not fair." There are some potential traps in that situation with retirement account. I mean, thankfully, the rule that the IRS gives us is any transaction that occurs incident to a divorce is not a taxable event. So if I splitting up the retirement account, we're just going to create separate accounts. There's a thing called a qualified domestic relations order that gets filed, a quadro.
Quadro.
And then the custodian splits the account out and everybody has their own account and it's a retirement account. If somebody chooses to take money out of it, then they're stuck with the tax consequences of that. But, let's say one spouse had a piece of real property. Say you guys had a house.
A house. Yeah. Yeah.
Sometimes it'll be like, well, you take the house and I'll take the cash. And sometimes people get really excited about that. Oh, I got this house that's going to be an appreciating asset, and you're just getting this cash, right?
Mm-hmm. Mm-hmm.
Well, think about that because once you own that house, now you've taken on the responsibility for any kind of tax consequences when that gets sold. You haven't increased your basis when you take the house in the divorce because there's no transaction.
Yeah.
There's no sale. So if let's say you buy let's say you bought your house for $200,000 15 years ago, well, and now it's worth $1 million, right? That's happened. If you say, all right, I'm going to take $1 million cash, and this other spouse takes the house,
Mm,
dollar house,
mm,
the bottom line, they've got the same amount of money.
mm.
But if the spouse who got the house goes to sell that house after they're divorced, they only have $250,000 of capital gain exclusion. And so if they have a $200,000 basis and they have a $250,000 exclusion, they've only excluded $450,000 of that gain.
Mm-hmm.
So now if they sell that house, they've got a $550,000
Interesting.
capital gain, and they're going to have to
Wow.
pay 20% of that likely to the IRS. And so what they didn't really get
Mm,
a
mm.
fair division of the assets. And so that can be an issue. That can be an issue with homes. It can be an issue with businesses. We've had cases where one spouse will want to sell the business. I have a business. And I'm going to sell my interest in the business to you, and you're going to give me cash.
Mm.
Well, that sale doesn't create a tax event because of the statute that the IRS has given us, and that's good. But it also doesn't give you any additional basis. And so if you pay $300,000 for that, your basis in the business is going to be the same.
You carried it over to yourself.
But when you go to sell the business, it's going to be as similar as the house. You're going to have
Interesting.
this built-in capital gain. So the built-in gains of the assets is something that you should be looking at when analyzing these
Yeah.
division of
Yeah,
assets.
for sure. No, that's hugely insightful. Now, to be clear for those listening, it's a little bit different when there's death, right? And some states will allow for like a 50% step up upon the death of the first. So that's a little bit different. But in the case of divorce, there is no step up.
Right.
There's no such thing. So yeah, that's interesting. So retirement accounts, pre-tax retirement accounts, same as brokerage accounts, taxable brokerage accounts. As far as what you receive, it's a $1 million retirement account pre-tax and $1 million brokerage account taxable. Fair? Not fair.
Oh, well, I mean, no, not fair. I mean, I would say
Not
not
fair.
fair because
Not fair.
again, you've got the built-in that a retirement account has a built-in ordinary income that's built into that,
Mm.
the ordinary income tax rate. Because when
There
you take
is
money
no
out of that,
basis. Like
there
it's
is no
as if
basis.
it were
Yeah,
zero. Yeah.
right. And there might be if it's a Roth IRA account, that's completely different. We're not talking about that. We're just talking about a traditional IRA
Yeah.
account.
Yeah.
So you're gonna receive that. And so let's take that scenario. You take $1 million. I'll take $1 million cash. You take the $1 million of retirement. Well, my $1 million cash is cash. I'm not going to have any gain on that
Wow,
ever in
no
the future.
gain at all. Yeah. Yeah.
But if when you want to access that $1 million of the retirement account, you're going to pay ordinary income rates on
Yeah.
every dollar you take out
Yeah.
of there.
Yeah.
And so
Yeah.
assuming a 35% tax, then really every dollar in that retirement account is really only worth 65 cents.
Yeah, and and unless like in cash, great example with cash, definitely not the same. Even in brokerage accounts with a gain, with a capital gain in it, the
Right.
gain they'd have to start at zero, which nobody really did that, right? There's at least some type of basis in that. So it's a very rare to zero occasion when those two would be considered fair and
Right.
equal. So yeah, it's
Right.
interesting. I've talked to a lot of people who just they got the house or they got something else, and one got the pre-tax IRA, and they thought, oh, okay, well this looks right. We're even. No, it's not. It's
Yeah,
not.
and I understand. I've sat in. We've got attorneys here who do divorce work, and I've sat in mediations and divorce mediations and brought these things up, and it can be like stressful because people come into those meetings with ideas about division, and sometimes I feel like I'm throwing a little wrench in the plan. But it's always important to always think about the tax consequences. Even in the brokerage account example you gave, you're trading an ordinary income for a capital gain asset. So the tax
Interesting.
rate difference is 35 to 40% and maximum
Interesting.
20%. And so yeah,
Interesting.
even though there might still be built-in gains, you might have more of an exposure in one than the other.
Interesting. Multiplying it by 20% versus 35, 38, whatever their bracket is, can make a big difference there as well. Yeah. Yeah. Interesting. So, last question here. We talked about old insurance, life insurance beneficiary designations and revocation on divorce laws, and
Right.
those colliding sometimes, causing expensive litigation between an ex-spouse and children.
Yes.
What needs to be done? What needs to be understood and known and help avoid some of those problems? First, explain what it is and maybe help us
Sure.
how to.
So the issue is that when you have an old life insurance policy, or you purchased a life insurance policy during the marriage, you typically have the spouse named as the beneficiary on that account. And when if I were to be that in that position, I passed away and I was married, my spouse would just get the money and it'd be fine. However, if I buy that policy and I get divorced and I don't go to the life insurance folks and change the beneficiary, my ex-spouse is still named as the beneficiary on that
Mm,
account.
mm.
Now, there's a law that takes care of that. There's a law that says any beneficiary designation that you've made for an ex-spouse is void as of the date of the divorce. And so there's a good argument to say if the spouse tries to claim that policy, that the kids can say, hey, no, the law says it's void, and the courts will support you in that.
Interesting. Mike, is that true just on life insurance, or is that true on like brokerage accounts too?
It's true on everything. It's at any designation of a beneficiary or a fiduciary relationship. So it's true for powers of attorney you've named your spouse. It's true for
Okay.
wills, trusts,
Okay. Kind of
all of
covers
that.
you if you forgot to do that.
Yeah. Yeah, and it makes sense, right? From a legal perspective, that we don't want somebody, just because they forgot to take their spouse off that life insurance policy, that the spouse gets a windfall, or that the ex-spouse gets a windfall when they pass away. The trouble arises in that, um, the kids have to know about that policy. The life insurance company doesn't know about the divorce. And so if the spouse passes away and the ex-spouse gets a notification from New York Life and says, hey, sorry to hear about your spouse's passing. You're named as the beneficiary. Please provide this information. Now, there should be something in there that says I am the spouse, or what my relationship is. But, we can't count on everybody being honest all of the time, or even understanding. And so that they may send in that claim form, and the New York Life will pay that out.
Wow.
And then if the kids find that out, they can sue the ex-spouse and probably recover based on what the law says. But is the money even there anymore? And what, you want to go
Wow.
through that process.
Wow.
So that's one issue. The other issue is, let's say we had this scenario where the ex-spouse agreed among themselves that the ex-spouse would continue to receive that policy if they continued to pay for it.
Mm-hmm.
So that was the agreement between them. It wasn't in the divorce decree, but that was the agreement post-divorce. They said, hey, let's just do this. I don't care about the policy. If you want to keep it, you can do that.
Pay for it and use it.
So the ex-spouse continued to pay for the policy, but they never went back. They never went to the life insurance company and updated the beneficiary after the divorce, because it's void, right? The statute says it's void.
I see.
And so when died, and the ex-spouse went to collect, the kids got upset about that and said, hey, no, life insurance company, you cannot pay her because the beneficiary designation was made prior to the divorce and it's void. And her argument was, well, we agreed and I've been paying for it. I've paid all the premiums on this.
Wow.
And that was a big problem. And because the law says she's not a beneficiary. So even though she paid the premiums, the court could have found in favor of kids could have walked away with that.
Is that right? So what happened? Did the kids,
They settled.
they figured something out?
The life insurance company doesn't want to be involved. So they paid all the money into the court. And then they had a mediation and they sat down and they hashed out some agreement, and they both walked away with some money. But I think obviously the result was not what they expected. So two things to remember. One, it's always a good idea, if you get divorced, go to your life insurance folks, change the beneficiary to your kids or your trust or wherever you want that to go.
Yeah. Yeah.
So that it's very clear that the ex-spouse is not entitled to it. Or if the ex-spouse is entitled to it, even in the divorce decree, if the divorce decree says this policy will go to the spouse, if you've got to go to the insurance company and change that.
Redesignate it with that date, because then the new designation will supersede anything that occurred prior to that.
Right, because the statute only applies to beneficiary designations made during the marriage.
Interesting.
And so if you make it after the marriage, then that statute doesn't apply, and then the ex-spouse can get that life insurance. And that's a typical thing, right? That somebody won't be able to pay alimony, or instead of alimony, they'll say, I'll maintain a life insurance policy for $200,000, and if I die in the next 10 years, then you can have that. So that happens quite a bit, but you just have to make sure that you're going and changing the beneficiary designation one way or the other.
Wow.
Otherwise, it can just create problems. Now, the law addresses it, but maybe sometimes you don't get the result that you were hoping for because of some of these default rules.
Yeah. Yeah. And it's so hard in those spaces, right? I mean, we've talked about these situations. These are highly intense, highly emotional, highly grieving, these are really, really, really hard times. And to remember all of those things in those times is really difficult. But you've given us some awesome things to think about. And I would say, Mike, if I may, to say one of the important things is during that time, seek some counsel. Seek somebody who's not in that emotional state or in that issue. It's going to cost you a little, but a mistake like that, right? Paying on a life insurance policy for however long and not getting the full benefit off of that. That's the price of an attorney or some advisors beforehand. It's a small price to pay if something like that were to happen later.
It really is. It really is.
Yep.
There's times in your life when getting the right counsel is paramount, and
And those times are it. And
those times
divorce
are
or
it.
death, or it's just a lot of emotions. Well, Mike, you have been amazing. So many cool stories, so much cool information. I appreciate you sharing that with us today. We're going to get this out and posted, and many people are going to benefit from it. So
Oh, thanks
thanks
for having me
again
on.
for your
Appreciate it.
time. Yeah, I appreciate it, Mike. Thank you.